Congratulations, you won your small claims court case. The judge ordered the defendant to pay you. You have a judgment in your hands. But here's the question. Will you actually get paid? And why does this matter? Here's the law. A judgment is only as good as your ability to collect. If the debtor doesn't pay voluntarily, you need to enforce the judgment. Today, we are going to walk you through exactly how to enforce a small claims court judgment and get the money you're owed. Step 1. Before you can enforce, you need the right documents. You need the signed judgment from court. This is the court order confirming the debtor owes you money. You need a copy of that order. The court clerk can provide this. Now, how to get started? The enforcement process begins with a notice of examination, requiring the debtor to attend court and answer questions about their assets. Under the rules of the Small Claims Court in Ontario, you can begin the enforcement process by serving the debtor with a notice of examination. Step 2. Here's how the examination works. What actually happens at the examination? The debtor must attend court and answer questions about their financial situation and the oath. They must bring documents to back up what they say. If the debtor is an individual, they also have to fill out a financial information form, Form 201, and serve it on you. Now, what happens if they don't want to cooperate? If the debtor was served with the notice of examination and fails to show up, or even shows up but refuses to answer questions, the court can order a contempt hearing under Rule 2011. The contempt hearing process itself, the court orders a contempt hearing, the debtor must appear at the hearing. If they can't give the court a good reason, they can be found in contempt of court. The court can jail the debtor for up to 5 days, though jail is one of 4 options available to the court. A warning here. Contempt proceedings require the case to be proven beyond a reasonable doubt, the same standard as a criminal trial. Step 3. Enforcement of the judgment. After examining the debtor, you can choose an enforcement method. Option 1, garnishment. You can garnish the debtor's wages or bank accounts. The court can order their employer to deduct money from their pay. Option 2, seizure. You can have a bailiff seize the debtor's property, but you must know exactly where the property is located. You cannot simply search for it. Option 3, a writ of seizure and sale. This authorizes the sheriff to seize and sell the debtor's property. Important notice. You need to know exactly where the property is located before you can enforce. The practical reality is that enforcement can be frustrating. If the debtor has no money, no assets, and no job, it may be difficult to collect, to say the least. Be realistic about the process. Getting paid is a process, and sometimes it takes persistence. So, in sum, here's your move. If you have a small claims court judgment, get a copy of your judgment from the court. Serve a notice of examination on the debtor. Gather information about their assets. Then choose an enforcement method. Garnishment is often the easiest. Be persistent. The tools are available. but you have to use them. Don't stop at winning a case. Collect what you are owed. This is iChat Law, where the law gets real. I'll see you on the next one.